Judge Elizabeth DiSanto's patience has been tested yet again, and in today's clip, she is confronted with a gentleman who just has no clue about anything, yet wishes to go pro se going forward. Then we have an update on a defendant who skipped out on his urine screen and ended up being on the wrong side of the Wayne County Jail. And finally, Judge Bryant gives an upbeat lesson on self-control, potato chips, and Popeyes. Enjoy!
Patrick 21534 and 231400. And Mr. Patrick, your name, please, for the record. All right, sir, you've waived your right to an attorney, is that correct?
No.
No, that's not correct?
I don't understand.
Sir, we have an attorney that went back to speak to you in the jail to represent you. And it's my understanding that you're refusing representation, you want to represent yourself.
Yeah.
Is that accurate? Okay, well, I need to make sure that you sign the waiver for him then in just a few moments. And so counsel, you don't have to worry about putting your appearance on the record because he waived his right to an appearance to an attorney. And Mr. Patrick, you understand that you do have the right to have an attorney represent you at all critical stages of the process, correct?
I don't hear it.
Sorry?
And again, louder. I don't need an initial. I need an initial.
Mr. Patrick, do you understand that you have the right to have an attorney represent you? So see, you're initialing that form there. See the paragraph up at the top?
I'm sorry?
The paragraph up at the top of that paperwork that you just initialed. Did you read that before you initialed?
I didn't understand. It says that I would be. It says that to the initial.
What does it say?
Be into, I can't quite read because there's a little bit of me in here. It would be partners to fill defendants. It's this one right here that you represent yourself. Oh yeah, that I represent myself.
And you understand that you have the right to have an attorney represent you, correct?
I don't need an attorney.
Sir, I understand that. I'm just trying to go over your rights with you to make a record. You understand that you have the right to have an attorney represent you, correct?
I don't have, I'm on my own.
Sir, please listen to what I'm asking you. You understand that you have the right to have an attorney represent you. That's one of the rights that you're afforded under the Constitution. You understand that, correct?
Yeah, but I don't understand why I had a warrant or anything. Why I was on my own.
You also understand that we have an attorney here to represent you today, correct?
I'm not for sure.
Sir, we had an attorney back there to speak to you, to represent you in your matter today. And you are choosing to represent yourself and not have one of our attorneys represent you. Is that correct?
On my own, yeah.
Sir, do you understand what's going on today?
It's Monday, right?
It's Tuesday.
Well, it's been 3 days already since Sunday.
No, sir. Since Sunday, it's been 2. Monday, Tuesday. Here, I would like to know, sir, do you understand why you are in jail?
No, I don't understand why.
Okay. Sir, I'm going to appoint an attorney to represent you today because you need to have some additional assistance. I'm not allowing you to represent yourself.
Fine.
So we will recall this matter. We're going to have Mr. Serrano go back and talk with him again.
All
We're going to go
right.
off the record. Thank you. Three 1400.
Your Honor, once again, Richard C. Serrano, P33828, appearing on behalf of Mr. Defendant.
And Mr. Patrick, hold on, sir. I have to wait for that to be unmuted.
Morning, Your Honor.
Morning. Good morning. Brian, can you hit unmute on there, please?
No, yes, she doesn't.
Okay, there we go. Okay, and so Mr. Patrick, your name for the record, please. Mr. Patrick, hold on, Brian, there's another button you have to push on there. I think maybe volume up, maybe. Okay, Mr. Patrick, can you state your name for the record, please? Let's go off the record. Okay, there's another button that has to get pushed there, Brian. Bobby, can you ask Joe what it is, please?
I see it.
There's some button. Oh, there we go. I got it. Now I can hear you. Okay. All right.
Yeah.
All right, so let's go back on. We're going back on the record in the matter of Paul Patrick. And Counsel, your appearance is already on the record. Mr. Patrick, your name for the record, please.
Oh, your name.
Oh, I want to be sure.
Your name, sir.
Just speak loud.
Paul Allen Petrick.
Okay, thank you. All right, and so, well, let's see. Today is Mr. Petrick's in custody because, well, I'm not sure on the 21 case if he ever reported he served his jail time on the 21 case. But in any event, Mr. Petrick is back in custody for a new charge. So, and the court did appoint the attorney to represent Mr. Petrick because he did not seem to understand the proceedings. And can you ask if on this, can you ask if he served that? Can you see what it says there? Because he served 93 days jail, credit for 93 days. I think so, yeah. Okay, so Mr. Serrano, as to arraignment with Mr. Petrick.
Your Honor, as to the newest charges, I've explained to my client the nature of the charges. He understands that. He understands all of his constitutional rights. This time we waive formal reading and stand mute.
Or wait for reading, enter plea of not guilty for purposes of the arraignment. And we'll schedule this matter for pre-trial June 27th. At 10:30 a.m., I'm sorry?
Is the older file going to carry with this?
I'm finding out the status of that because my notes show that he was sentenced to 93 days jail to serve 93 days. Or he was sentenced to 93 days jail, credit for 93 days. So I'm just waiting to see what the status of that is.
And that's what my client told me.
Yeah, so I'm not sure why that, okay. Great. as to bond counsel.
Your Honor, my client is currently on Social Security disability. He is not working, obviously. He has one child, age 24, that lives with the other parent in Colorado. And Your Honor, he tells me he does not believe he has anything else pending. He's not on probation or parole, other than what the court has ordered him to do in the past prior cases. But he does not believe anything is going to affect his ability to come back. He's a high school graduate. Your Honor, I think he's a good candidate for a personal bond, or bond he can reasonably expect to post given his situation.
Mr. Petrick, I'm sorry, where are you living?
Southgate.
I understand that, sir. Are you at a hotel or a home?
Southgate. Okay. And all the above. Oh, it's 1573 Southgate, Michigan.
1973. 1973, okay, sir, are you residing in a hotel?
Motel, I have, but I sometimes stay with my parents and I go to the motel.
Well, so where does your client live?
He tells me Southgate.
I understand that, but
Southgate. Well, yeah, America.
who did you say you live with?
I live with my parents.
I don't think that, I think that that's a motel.
Yeah, there's a hotel. Yeah. Well, but there, I live with my parents in Southgate. What street? It's Samhain. What? Samhain by Perch, or Kirk's. It's by Trenton Road. Samhain? Yeah, Samhain. It's next to, I think there's like 2nd Street over in there.
Sir, you have listed 14,000 Dix Avenue as your address. That's the post office.
Yeah, that's the post office. That's
Correct.
well, on my other license that I have with the black shirt, it says 1573. The white one says, Dix Code on 14. That I stood at a motel for an address to be there like that. Cause I live with my mom. I'm Samhain, but that's there like that.
But what?
Your Honor, could the court ask him where, if you were released, where he would return to?
Oh, I returned back to Southgate.
I understand that, sir. I'm just trying to figure out where that would be.
Oh, where that would be?
Where would you go? In Southgate.
Oh, that's right off of Rico. Right off of Rico by a movie theater.
Do you have an address for that location, Mr. Bittner?
1570 Samhain. 1573 Samhain.
1573 South? What, South is the name of your street?
Samhain.
Selwyn. Selwyn.
Thank you. Okay. Okay, here's what the court's going to do. the court's going to indicate a $2,500 10% bond. In the event bond is posted, GPS cover the Wayne County Jail, so we can confirm that Mr. Petrick will appear. He has history of not appearing on his other matter, and I'm just waiting to see what's going on with his other matter. That's without consuming alcohol or drugs unless prescribed. Right. Okay, and then on the 21534 matter, we're going to adjourn that also to June 27th. And we're going to figure out what is going on with that, because it indicates that Mr. Petrick did not, he was in the Wayne County Jail when I recall the warrant. So there's something in the Wayne County Jail system that's not updated, counsel. That's 10:30.
Your Honor, the court may recall that Mr. Petrick originally said he was waiting for counsel. Excuse me. I talked to him now twice. He seems to want to do that again, waive counsel, but I'm at the court's discretion. The court does not find that Mr. Petrick has the capability to represent himself, so the court's not allowing him to waive. Fine, Your Honor, I'll stay on the case.
Daniel Robert Walters.
All right, thank you. And so today is the adjourned pre-trial date. And counsel?
Your Honor, I've had an opportunity to discuss with Mr. Walters this particular matter. As the court indicated, this is the adjourned pre-trial.
You're very quiet, Mr. Walters, because there's a lot of background noise here. So I need you to be as quiet or as loud and into the microphone as possible, please.
Thank you, Your Honor. I'm sorry. Your Honor, yes, I had an opportunity to discuss this matter with him. It's my understanding that in return for a plea of guilty to the, I guess for lack of a better term, a more palpable charge of disturbing the peace based on these circumstances, the original charge of disorderly conduct would be dismissed. I've discussed with Mr. Walters his constitutional rights. He doesn't understand that by entering into this plea agreement, he will be waiving certain constitutional rights. I've also explained to him, since he is on probation in Woodhaven District Court, that this could, depending on how it turns out, have an adverse effect on his probationary status. With all that said, Your Honor, it's my understanding that he wishes to enter into this plea. Is that correct, Mr. Walters?
Correct.
Okay. Mr. Walters, please raise your right hand. You solemnly swear from the testimony you have given us today the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you heard the plea that your attorney placed on the record, correct?
Correct.
And as to an amended charge of disturbing the peace, how do you plead?
Guilty.
And you've gone over your rights and rights with your attorney, correct?
Correct.
And you understand all of those rights?
Yes, I do.
You also understand that by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights?
I do.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency, correct?
I do.
And you also understand that since, as your attorney indicated, you are on probation in the 33rd District Court, that this could trigger a probation violation. Do you understand that?
I do.
And knowing all that, you want to continue with your plea.
Correct.
And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, they haven't.
All right, counsel, if you can please body your client.
Thank you. Mr. Walters, back on April 4th of 2023, were you at an address located on 14th Street in the city of Wyandotte?
Yes.
And at that address, did you knock on the doors and create a disturbance thinking that you were at your new home?
I did.
And had you just moved into that neighborhood?
I did.
And did it come a point in time when the police responded to these actions?
Correct.
And when you were trying to get into this home or getting the attention, what were you trying to do?
I was trying to get into the home to have my roommate, who I thought was there, drive me up to the hospital because I had just wrecked on my bicycle and I was concussed. I'm pretty sure I never made it up to the hospital, but I mean, I'm pretty sure that's what happened. I needed to go seek medical attention.
So at the point in time when you were disturbing the peace in the neighborhood, it was because you were misguided as to what your new residence was. Is that correct?
Correct. I was mistaken as to where I was exactly.
I'm satisfied, Your Honor.
The court is also satisfied the plea of knowing, voluntary, and factually accurate as far as that goes. Although I don't really buy part of Mr. Walters' explanation because I'm looking at two different addresses for Mr. Walters, none of which are on 14th Street.
Your Honor, it's my understanding he had just, about a week or so ago, moved into that address. That's what he was.
Week or so ago from today?
No, prior to.
But he doesn't have that date listed or that address listed on any of his paperwork.
The
Mr. Walters?
3404?
Yes, that's on
Yes.
15th Street, not 14th.
Correct. I thought I was on 15th Street. I don't know if I was on 14th Street or if there was a mistake in the paperwork, but I'm pretty sure I was on 15th Street. So, I don't know. Like I said, I had a pretty gnarly accident on my bicycle like minutes before that. So, I could have been mistaken. Easily could have been mistaken.
Well, given the address on 14th Street, you're a significant distance away from your home on 15th Street.
I'm aware. After I got out and I went back looking for my belongings and stuff, I realized how far I was and how ridiculous it kind of was. But I mean, there's really no excuse.
You mean after you left the courthouse before you did your testing, as this court ordered you to do?
No, after I got released from jail.
Oh.
I went back looking for my bicycle and my backpack and my jacket and everything, which I don't know what happened to them, but I went back looking for them and maybe I couldn't find them because I was looking on 15th Street and I was on 14th Street, or they got taken or something, I don't know. But that's neither here nor there, I guess.
All right, well, the court's going to set this matter for sentencing on the June 27th.
I'm sorry, Your Honor.
June 27th at 10 a.m. You're on the docket that day.
Yes, Your Honor.
And so, counsel, what I'm going to do is I'm going to have, I'm going to check with Wayne County Jail, see if probation can zoom in
Thank you.
for the pre-sentence interview.
Thank you.
All right, and then the court's going to indicate bonding conditions are continued. We're going to go off the record for a moment. Wayne County Jail, Division 2, is it possible for me to have probation zoom in to conduct a pre-sentence interview with Mr. Walters, or do you need the camera?
Yes, Judge, if you wanted to complete the PSI now, we have cameras available for that.
Perfect, thank you very much. I'm just going to mute you for a few moments and I'll put,
I apologize.
All right, thank you.
okay, so we're going to go back on the record then. this is back on the record, the man named Daniel Walters.
Your Honor, Mr. Walker did ask me to ask you, now that this has, I'd like to get a personal bond, Your Honor, rather than the $2,500.
Is that into the microphone?
10% so that he can get out, maintain, or try to get things straightened out now and litigate as well as get returned to work. Yes, Your Honor.
Okay, well, and I can appreciate that, counsel, but here's the thing. On April 18th, your client was before the court for a free trial. We adjourned it to May 2nd for some, I don't say investigation, but research into how anything would affect the 33rd District Court probation. This court had concerns that your client was under the influence of some substances, as it's alleged he was the night of the offense. That's perhaps why he was so confused as to where he was at.
That's correct, Your Honor, and I agree with that.
And this court then ordered your client to go over to probation and test immediately. The client took off. He did not test, did not contact the court again until he ended up arrested on warrant, and the court recalled the warrant, set it for today's date, and issued a $2,500 10% on GPS covered through the Wayne County Jail. Your client, I do not have confidence, would be appearing for court, given the fact that he was at court and took off. And so that is why the court issued the bond that it did.
No, and I understand, Your Honor, because I was here when that bond was issued. I mean, the last. No, I do understand that, Your Honor. You just asked me to ask.
I understand. So the request to reduce your personal bond tonight on the conditions are continued. Thank you.
Thank you, Your Honor.
Yes, sir?
If I may, I have the money to post the bond, I just don't have it with me, it's at my house, right? But, I would definitely show up for court, especially, I mean, if you put a tether on me, I wouldn't have any other options, you know what I mean? And the whole reason I took off is, I mean, I really wasn't thinking too far in the future, but I can tell you from my time here, especially this past 2 weeks and being where I'm at now, I would never want to risk coming back here or anything to jeopardize anything to make this continue like that. So, I mean, I would definitely show up to every little thing that I would have to in your court, and I would come with as much money and as much evidence and whatever you would ask of me. I mean, I don't know how to.
Well, sir, you can certainly make a phone call and have somebody post the bond for you.
I've tried to call and nobody has been able to either get it or care enough to either answer the phone, or I don't really have too many people to like look out for me, if you understand. If I really just have myself and a few friends, but they're all out of state and haven't answered the phone because they don't recognize the number.
Okay, sir. I placed the reasons why the court's not amending the bond. And if you want to see if somebody can contact your people outside of jail to post that bond, you can certainly do so. So I don't know if you want to provide some phone numbers to Ms. Shaw as you're interviewing with her, and she can provide them to Mr. Goldpaw. I don't know, but those might be some options to contact somebody on the outside for your fund, but the court's not amending the bond.
Thank you.
Thank you. All right, we're going to be off the record, so I'm going to have you go into breakout room 2, and you can complete your pre-sentence investigation interview.
Are we doing this choice next?
Yeah.
Thank you very much.
We are on the record in the matter of the City of Wyandotte versus Amani Choice, 23936. And appearance, counsel?
Good morning, Your Honor. Your Honor, John Goldpaw, P. 30758 on behalf of Ms. Choice. Ms. Choice.
Poor Judge DiSanto. The defendants just get more challenging by the day. Both of these brain surgeons either had no clue what day it is, or was so high they had no idea where they were. Next, we have Judge Bryant dropping words of wisdom about gambling, eating, and just working on yourself. She is just a wonderful person. Thank you, Judge, for being you. Let's watch.
Hey, based on Mr. Johnson's comments, I do applaud you. I applaud every person who comes in my courtroom and is charged with this crime, because I was talking to a friend of mine and I was saying, I don't know that I would ever voluntarily put myself on a list that could then result in criminal prosecution of myself. And I said, people who put themselves on the list are either naive at the time, like some of the younger people, and they gamble a little bit and then they don't know. And then at the time they didn't know, it used to be you had to be on the list for a lifetime, which I was vehemently opposed to. And so I'm so glad that they changed it. But like, for example, Mr. Wheeler, I often joke about myself. I don't mind talking about my own self and, acknowledging the issues that I do have. But I generally sometimes tell people about, I've never been addicted to drugs, will never be voluntarily addicted to drugs, unless somebody kidnap me, and do whatever. But no drugs, not addicted to alcohol, not addicted to, but if you put some chocolate and some Lay's potato chips in front of me, it's like I'm just gone. I'm completely gone, right? That's one of the reasons I started ordering my groceries, because when you go into the grocery store, they right there, like you walk in, the big old family bags and stuff, right?
Yeah.
But even knowing how much I can't necessarily self-control myself and I need to. So now I need to. I do applaud people who would voluntarily put themselves on a list, because I don't think I would ever put myself on a list that banned me from buying Lay's potato chips. Like as much as I know I need to be on the list, I wouldn't do that. So I applaud you.
You're right, Joe, because I put myself on the list. I walked in to the General Motors building. I knew I needed help, and I went there to get help.
Right.
And I put my own self on the list to stop me.
Right. And I guess I wouldn't, I shouldn't say I would never put myself on the list. My doctor said, if you eat another Lay's chip, or if you eat too much and you're going to die, I'll go put my name on any list. And if you see me coming in here, don't. So I do applaud you. And I want to, so I'm going to go ahead and sentence you. I'm going to sentence you to 9 months probation. That means you're eligible for discharge after 4.5 months.
Okay.
I'm going to give you a review date of October the 10th at 10 o'clock. That's your review date. Your 9-month discharge date, if you don't finish early, is March the 12th, 2024. That's 9 months. But I'm going to give you a halfway point review date of October the 10th at 10 o'clock. If you complete the terms and conditions of the probation that I'm going to give you right now, then on October 10th, if you complete it by October 10th, I will discharge you from probation. I am going to impose the following. Well, first, you shall not violate any criminal law of any governmental unit. I'm not going to restrict your movement, so you can leave the state of Michigan. May leave state without permission, so you can leave state. And then it's going to be a non-reporting probation. However, I do want, I'm going to have probation touch bases with you so they can give you the referrals to Gamblers Anonymous and Gamblers Counseling. I do want you to engage in at least 3 months of Gamblers Anonymous and Gamblers Counseling. Because if you get ready to take your name off that list, I want you to have some tools to help you if you take your name off that list so that you don't lose everything. Because I won some money on that cruise. I won some money, but let me tell you who got my winning. Let me tell you who got my winning.
It's addictive.
Let me tell you who didn't get to spend her own winning. Me. That first day I cashed out my little ticket, I should have stayed gone. But then you kept walking past the little casino. You kept walking past the little casino on the boat. That's why they put it where they put it. And then you kept hearing the little thing.
Well, they say it's not about being needy. Sometimes you're greedy.
That's right. Or something.
That's what happens.
And Mr. Wheeler, the little games on there is fun. So this is why you should, if you have a problem, just stay away. Stay away.
Yeah,
So
they know how to play with your emotions.
they do.
High and low. You win, you go down, up and down, and they know you're gonna come back.
Right. So I'm glad you, oops, my little camera fell. I'm glad that you put your name on there if that's what's necessary to help you. But I want you to get at least 3 months of Gamblers Anonymous and Gamblers Counseling under your belt. And then, so while you are on probation, Mr. Wheeler, whether or not your name gets taken off the list, you can't go into the casino until I discharge you from probation.
I understand that. I
Go
respect
ahead
that.
and if you want to take your name off, but until I discharge you from probation, you have to stay out of the.
I can show proof that I'm working with my issue.
Yes. And so our court is going to impose mandatory cost of $210, a $150 fine, for a total of $360. And you have until the March 12th date to pay, but if you pay before October 10th, then you'll get discharged. Additionally, as I indicated, you're going to attend Gamblers Anonymous and Gamblers Counseling. If you have any tickets with the 36th District Court, you must either pay them in full or get on an approved payment plan with the court. So I didn't do a pre-sentence investigation, but you need to have them run your name. If you have any tickets, you need to pay them in full or get on a payment plan to show that you're paying on them.
I have no tickets.
Awesome, that's great. Cause you don't be driving, you be just in the casino. I'm just messing.
No, I'm tired of giving them my money. That's why I put myself on the list.
I know that's right, cause I was mad. I gave them the money. I was mad. I gave them the money that I won. I said, wait a minute.
And then they say the worst thing is to do is try to go back and recoup your loss.
Oh
when
yeah,
you lose, just walk away. It's hard to walk away.
Mr. Wheeler, that's what me and my friend did. We talked about, I'm gonna go back and get my money.
It don't work like that.
It don't work, and that's why I'm thankful for the list to let people to help. You know, the people who really need the help. I mean, I haven't been to a casino in I don't know how long, and then again, you know, it was just on the boat, so I don't need to put my name on the list, even though I lost that $100 and some. But I'm thankful for the list for people. Who, all right, so Mr. Wheeler. Probation is going to contact you to give you the referrals for the Gamblers Counseling and the Gamblers Anonymous.
All right.
So I do need, Mr. Johnson, you to contact my clerk so that you can give them the current address and phone number for your client. Okay.
Okay, Your Honor.
All right, and then of course that's 2295 is my last four numbers. Okay, Mr. Wheeler, I'm going to see you on October 10th on Zoom at 10 o'clock, and hopefully you would have completed 3 months of Gamblers Counseling and Gamblers Anonymous, paid the $360, and I can release you from probation, okay?
No problem.
You have a great day and stay safe. Mr.
And Judge,
thank you for your time.
Okay, you're welcome. Mr. Riggs, did you have something?
I did, Judge. I've been writing here. I just wanted to make sure the court has therefore granted Mr. Johnson's request for treatment under 771.1, and if he successfully completes the probation and the requirements that you have set forth, that you will dismiss at the conclusion if he successfully completes everything you tell him to do, right?
Yes, and I apologize if I did not say that on the record. I did check it on my sheet. This is, I am taking the sentence pursuant to MCLA 771.1, okay?
Thank you, Judge.
All right, you're welcome. Everybody have a great day. Stay safe.
You Judge, is it okay for me to drop that bag of Better Made potato chips off at your courtroom?
I don't really like Better Made.
I got the chocolate.
Let me say this.
I knew you was gonna kick. Hey, Judge, I knew you was gonna kick back on the Better Made.
Listen, and let me tell you, and I'm a diehard Detroiter, Mr. Johnson. But for some reason, you know, well, I know what the reason is. Let me tell you, Lay's is saltier than the Butter Made. Now, mind you, if the doctor ever see this, she's gonna be like, that's all the more reason you shouldn't be eating the Lay's. But I don't know what it is, Mr. Johnson. The Butter Made, it won't do it. But maybe, so see, you all have helped me. Miss Johnson, maybe I'm going to switch to the better maid.
Hey, Judge.
That'll be like
Hey, Judge.
that'll be like some methadone. Switch to
Hey, Judge, I had a few better made with my hot dog last night.
I'm going to switch to the better maid, and that'll be my methadone. And then maybe that'll help me just come off of. And sometimes, look, maybe the better made people are watching my YouTube, because sometimes they have too many burnt chips in the bag.
That's the biggest complaint with better made people have.
You get mad. You're burning up chips. The people ain't paying attention to when they cooking them chips. Okay.
Right.
Mr. Wheeler, please accept our apology.
No problem. This is therapy. This is good therapy.
All right. We do take this matter seriously, Mr. Wheeler. That's just a little bit of, laughter is good for the soul, okay?
All right, Judge. Have a good day.
Right. Have a great day. Stay safe.
Take care, Judge.
All right. Thank you, Mr.
All right. Thank you, Judge.
You're welcome.
I hope one day meet you.
Yes, I hope so too.
On the good side. On the good
That's right.
side.
On the good side. All right.
All right. We'll talk to you later.
Okay. Bye-bye.
For Miss Perkins, first thing for Miss Perkins, she will be gone June 14th to June 18th.
Mr. Flanagan, put that in the register for me.
And the second thing, the burnt chips are the best part, Your Honor.
Oh, Mr. Bird, you ought to be ashamed of yourself. Them burnt chips, well,
I like better made.
Because you like the burnt ones?
I like the burnt ones.
Oh.
Well done.
Well, then let's
take a poll, Judge.
We're not taking a poll. We working. It's 12 people in the waiting room. You want to take a poll about the better made chips. And I have 32 jurors waiting on me to be finished in 10 minutes. Okay.
And it's Mr. Bird's birthday, Judge.
Today is?
Yeah.
Today is.
What are you doing here? Happy birthday. My birthday is a national holiday. In my mind, everything shuts down. Nothing is working except wherever I'm at on vacation. They need to work.
Nothing better than making a little money on your birthday.
Well, I guess so. Well, see, when you work for the government, your check don't change. You've been here so many years and your check just don't change. All right. Okay, back to the regular mode, as you all have taken me off of my serious face that I need for the defense. Now they probably watch it on YouTube and they like, oh, she be laughing and stuff. She ain't mean. No, I am. Let me go back to that page. All right. Then I need to readdress whether I'm going to transfer the case to Judge Garrett's docket. All right, anything further?
Judge, may the people have that adjourned pretrial date again? I'm sorry.
July 6th.
Thank you, Judge. Nothing further from the people.
Thank you, Judge. I'm so sorry, Your Honor. I wrote down July 10th. It's July 6th.
Okay, now I need y'all to pay attention. I'm not going to repeat myself 5 times.
Sorry, Your Honor. It won't happen again.
Okay, thank you, Mr. Moran.
Thank you, Judge. Nothing further.
All right. Mr. Hopkins, give us until this afternoon before you try to go to the tether unit.
Yes, ma'am. Thank you, Judge. Your Honor.
Have you went to Popeye since that time?
No, I haven't been. I just been straight to work.
Okay, well, keep doing
I have my wife go.
Oh, she went to Popeyes for you?
Yeah.
Stop eating all that fried chicken. Stop eating all that fried chicken. Mm-mm.
Yes, ma'am.
It's not good for you. Go to Boston Chicken.
Right.
All right.
Okay.
Have a great day. Stay safe.
Thank you.
Bye-bye.
Those were just great. Judge Bryant definitely should have taken that potato chip poll. Make sure to hit the like and subscribe buttons and set your notifications to all so you will never miss these golden nuggets. Bye-bye for now.